The final matter to come before us this morning is Craig Padula versus Brian Wagner. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve that time, and let me know when you get started. I'm keeping the clock this morning. I can keep you apprised of the passage of time. The court's read the briefs and we are ready to proceed when you are.
Good morning. May it please the court, my name is Dan Linder. I'm the attorney for the appellant. I'd like to reserve 2 minutes for rebuttal, please. This is a case about a litigation that was dismissed under 12C, Civil Rule 12C. Now it gets to the merits. It is simply review the pleadings. The pleadings are involving 3 documents which are contracts, one of which is disputed as a contract, whether it's a contract or not, but 2 which are not. The 2 which are not are an employment agreement and a document called Covenants of Employee. Now the language of these documents were actually, even though they were attached and incorporated therein, the language is actually typed into the brief, into the complaint itself. The employment agreement says this is a term of employment for 2 years. It can only be terminated by death, disability, or for cause. The terms for cause are written, the term for cause is defined. Plaintiff, of course, alleged, I was terminated without cause. The covenants of employee say, I incorporate the terms of the employment agreement. And the term of employment is defined by the employment agreement, but this is an at-will contract. Well, wait, gosh, you have 2 documents, each of which incorporate one another, that have, on their face, conflicting terms. One says it's for cause, it defines for cause, there's a whole paragraph there about for cause. And there's another one that says it's at will, even though I'm relying on the definitions in the employment contract that say for cause. Now, a fact that's pretty important to that discussion also is that the entire document was drafted by the counsel for the appellee, who's going to come up here and tell you that doesn't create an ambiguity. But, of course, in a Rule 12C motion, which is what the court was considering, you take the pleadings at their face value and the inferences that reasonably arise therefrom, and you assume they're true. And you have to find that, specifically, it is beyond doubt that the plaintiff can prove no set of facts. So you have 2 contracts that everybody's signed that have 180-degree conflicting terms. We have no parole evidence, you can't consider outside evidence yet. All presumptions are to go in favor of the plaintiff. There is absolutely no basis, none whatsoever, for the court to have dismissed this case. Secondarily, let's say, and the court, by the way, cites to a paragraph 6 of, I believe it's the employment agreement, to say that shows it's at will. That paragraph 6 never uses the words at will. It requires inferential findings by the court, of course, which are all supposed to be in favor of the plaintiff. But it says that it says if the employment is terminated for any other reasons other than previously listed, here's what happens. And so the court says, well, that means at will. Well, no, it doesn't. It means there's lots of other ways for employment to end, not the least of which is the parties agree, this just isn't working, tell you what, you pay me some severance, I'll walk out of here, you release me from my covenants, we're done. It could be by agreement. But, again, inferences are supposed to be drawn strictly in favor of the plaintiff. Therefore, the court can't make the inference specifically without the wording there that this was at-will employment. So the case should not have been dismissed there. Similarly, like I said, at minimum, you have ambiguity because you have 2 conflicting terms, again, construed against the drafter if such a thing occurs. And certainly the court, another contract principle, court isn't to write contracts. It's supposed to use the language that's there. And this for-cause definition, by definition, has to have meaning. The words can't be presumed in a contract and not have meaning. And this happens to be well-defined, for cause. Now, the drafting overall of the documents, maybe less than perfect. In fact, definitely less than perfect, but that's ultimately for the parties to talk about what was the intent of the parties in a contract, which itself is a question of fact, which would preclude a dismissal at 12C. Then we also have this document called a term sheet. The term sheet has very specific terms, one of which is that in consideration for my client leaving his former employment and coming to work for a term of years, he has a right to purchase this business at the end of the 2 years. It has purchase price. It has seller financing terms. It has closing dates. It has mechanisms by which it was supposed to occur. It has pretty much, it has more than every necessary term to be found to find the contract. And it's called a term sheet. And so there's an indication there will be further documents created in the future.
Within the next 60 days.
Within the next 60 days, exactly.
Was that done?
I was about to get to that. The answer is no, and it says it was to be negotiated between the parties in a commercially reasonable manner within 60 days. And the answer is no, and again, the drafters of all this stuff are the employer, the appellee. It never moved forward.
Does the complaint allege a cause of action wherein it alleges there's a violation of the term sheet specifically?
Yes.
What is that allegation?
That the term sheet was in fact a contract. It was an agreement to agree under this court's case of Telpson, T-E-L-X-O-N, they should come up with an easier name, Corporation versus Smart Media. That cites Ogilvy, Norton, and Bergeon, which are both Ohio Supreme Court cases. Agreements to agree that are reasonably definite in their terms are in fact contracts. The complaint actually pleads that and says that they breached this contract as well. The court dismissed that part right off the bat.
How long was Mr. Padula actually employed by? How many days did he work here?
Yeah, the employment started, let's write this down here. It was just a little over 1 year, not much over 1 year. He was, I should write them down. Here we go. He was supposed to be able to work till July of 2013. He was terminated in December of 12. So, and I'm doing that from memory. I specifically wrote the dates down. I'm looking for it. But it was roughly a year. It was a month or two more than a year. So he was terminated, and of course, the fact pattern that goes along with that is he had brought in more business to this company than the company had ever done in its history.
Was employment termination a breach of the term sheet?
Yes. The term sheet,
Is an agreement to agree regarding business sale?
the first paragraph is, part and parcel to this, they're entering into an employment agreement. That's the first paragraph of it. But this gentleman was about to get paid. This contract goes out and takes bids on contracts. He had received in book contracts totaling a little under $20 million. The company had never done that kind of business before. The first deal was about to close, and he was about to get paid his commissions. And that's when they terminated him. So we're talking about a significant commission. We're talking about significant money brought to this company. Because these are publicly bid contracts, you can see on websites that they actually did close. At least, I think 2 of 3 of them did. They actually did close, and this was done specifically at the last second, the bait and switch to fire this guy who's about to get paid his big payday. And again, this company had never in its history done this kind of business. But of course, that's outside of the pleadings. That'll be proven, should this matter be remanded, and it should be remanded, reversed and remanded. But this, but that's also the basis for the bad faith and the estoppel and the unjust enrichment counts, and recognizing that if there's a contract, not all of those survive. But they were pled in the alternative, particularly since there's a debate over whether the term sheet is itself a contract. In short, if you're presuming everything in the complaint as true and all reasonable inferences therefrom, there was no way to dismiss this case at that point. We hadn't even gotten to the substance. The court was making inferences from words that weren't in the document, and they were doing it in favor of the employer, which you can't do.
Can you address the transition agreement quickly?
Yes. What happened is, and the reason that was added, my client, everything's going along swimmingly. All of a sudden, his brother-in-law, the employer, comes walking in with a document that says transition agreement. It materially changes all the contractual terms of all 3 of these documents. It says, I'm going to fire you. You're going to be fired on this date. You're going to still be bound by your restrictive covenants. You're going to get paid some sort of money. I can't tell you the details because it really isn't all that important other than the fact that it is a clear anticipatory repudiation of the contract. He's like, sign it or you're fired. Well, that's not cause. And it's not permitted under the contract. He said, sign it or you're fired. It was the old gun to your head. My client said, I'm not signing that. I refuse to sign that. And sure enough, he was fired. Not grounded. That in itself is an evidence of bad faith. That also is evidence of anticipatory repudiation, which ultimately could become an issue in the merits part of this case, because there will be a question of who breached first at some point on this, and we believe that anticipatory repudiation will predate anything that they could ever allege my client would have failed to do under his contract, which we don't believe is anything. But I'm sure there will be an argument regarding it on the merits. And by the way, if there was a for-cause firing, it required a 30-day written notice. It required 30 days written notice before he was to be terminated. Again, which in its face flies in the face of at-will employment. By definition, it's not at-will employment. And we of course never received that 30-day written notice. Having said that, I don't have that much more to say about this. To me, this is screamingly obvious. I'm hoping the same is true for the panel, but I'm asking this court to reverse the trial court and remand all counts to be tried on the merits. Thank you.
Good morning, and may it please the court, my name is Robert Zimmerman. I represent the appellee CCG Energy Solutions. This appeal turns entirely upon 3 documents that were attached to Mr. Padula's complaint: his employment agreement, the covenants of employee, and the term sheet. They were all dated and executed July 27, 2011. Those are the merits, and they were reviewed by the lower court. That is all before the court right now, not things that were conceded that were outside the pleadings, like websites and other deals that were closed at some point after this case was filed. The documents all reference each other, and they're part of an integrated whole. They evidence the parties' intent that CCG was going to employ Mr. Padula for up to 2 years. While Mr. Padula worked for CCG, the parties were to negotiate final terms of sale of CCG to Mr. Padula at the end of those 2 years. But that transfer of ownership was not guaranteed, and it depended upon the execution of what were called definitive agreements, which had not been negotiated or signed at the commencement of the 2-year employment term. Both of the parties retained the right to walk away for a reason or no reason during the up to 2-year employment period and not go forward with the sale. And that's what happened. So with respect to the term sheet, we'll speak about that first. Mr. Padula seeks a declaration that the term sheet attached to his complaint as Exhibit 1 was in fact an enforceable contract for the sale of CCG to him. And he's asking for specific performance compelling that sale and for damages for an alleged breach. Those claims collapse under the very weight of the document he seeks to enforce. The very first line of that document said, and I'm quoting, "This term sheet reflects their present intentions with respect to the sale by Wagner to Padula of all the outstanding shares in CCG. Wagner and Padula agreed that any binding agreement with respect to the sale will be set forth in one or more definitive agreements executed by them," close quote. Indeed, the term sheet said that certain draft documents, including a stock purchase agreement, term note, and pledge agreement, along with any other required agreements, which at the time didn't exist, will be the basis for the future definitive agreements. The term sheet said that it was only at the expiration of Mr. Padula's 2-year employment term that Wagner would sell him the shares in CCG, presuming the definitive agreements were executed. It could not be more clear that the term sheet was not the purchase agreement. It was simply a step to, a roadmap to the purchase agreement, but many things had to happen in between that point. And ultimately, a binding definitive agreement was necessary to sell the company. And that is why the lower court correctly and properly dismissed Mr. Padula's claims based on the term sheet. It was not a contract that could be enforced or breached. And as a result, there is no implied obligation of good faith and fair dealing. And for that reason, Mr. Padula's equitable claims for promissory estoppel and unjust enrichment were also properly dismissed because there was no promise to sell the company that he could reasonably rely upon. Again, it was just a term sheet, a roadmap. With respect to the claims based on the employment agreement and covenants, those are exhibits 2 and 3 to the complaint respectively. Mr. Padula alleged that CCG breached these contracts by terminating him without cause, and that he's entitled to damages. The court properly dismissed these claims based on the clear language in the operative documents that Mr. Padula was in fact an employee at will, subject to termination at any time for any reason or no reason, not contrary to law. In his brief, Mr. Padula points to the term of employment language set forth in the employment agreement as evidence that he was not an employee at will. But that language doesn't help him. The employment agreement attached to the complaint is Exhibit 3, and Section 1 says, and I quote, term of employment, duties, that the term of employment will commence on the date of this agreement and continue for a term of 2 years unless earlier terminated as provided in the agreement. So right there in the definition of term of employment, it clearly states that the 2-year term could be earlier terminated as provided in the agreement. So what does the agreement say about earlier termination? Well, there's a number of reasons why we could have an early termination. Section 3, Mr. Padula's death. Section 4, his disability. Section 5, his commission of certain enumerated offenses. And finally, Section 6 stated that the term of employment can be terminated without a reason by CCG or Mr. Padula. And it says, I quote, in the event the term of employment is terminated by either party other than pursuant to Section 3, 4, and 5, employee will be entitled to receive any base salary and benefits earned and accrued but unpaid through the date of termination and any unreimbursed expenses, close quote. So, the employment agreement, therefore, had provisions for termination with cause or without cause within that 2-year, up to 2-year employment period. That is the definition of employment at will. And to make that even more clear, Sections 7 and 9 of the employment agreement referenced and incorporated the covenants of employee which were attached to the complaint as Exhibit 2. The covenants specifically referenced the employment agreement. They all fit together, signed the same day. In Section 1 of the covenants of employee, Mr. Padula explicitly stated that, and I quote, I understand that my employment is employment at will, and as such may be terminated at any time, with or without cause, as defined in the employment agreement by either myself or CCG. So, close quote, putting all the pieces together, reading everything together, there was a term of employment for up to 2 years with escape hatches for both parties to end the employment relationship before the end of the 2-year employment period. CCG could have terminated Mr. Padula upon his death, disability, enumerated offenses, or for no reason at all. Mr. Padula also had the right to walk away for any reason or no reason. If he decided this just wasn't the place for him anymore, I don't want to work here anymore, I don't want to own this company, I'm walking away. He had that right, and the agreement made clear he could leave at no penalty to himself. So consistent with this, the covenant stated that Mr. Padula was an employee at will. None of the cases that Mr. Padula cited involved employment agreements with such clear language demonstrating employment at will. But there is a long line of cases, including the Soy versus Ross Incineration Services case decided by this court, and written by you, Judge Rick Whitmore, that have upheld at-will terminations based on employment language similar to that present in this case. The Soy case is very important, decided by this court, because in that case, this court upheld a termination of an at-will employee based on at-will language, even though that at-will employment agreement also contained just cause for termination provisions. That's our case. So based on this law, this court should affirm the decision of the trial court dismissing the declaratory judgment of breach of contract claims based on the employment agreement and covenants. I should also mention that the trial court properly dismissed the promissory estoppel and unjust enrichment claims based on the existence of employment documents. And as for the bad faith claim, it is very clear that there is no separate cause of action for bad faith in the contractual setting. There was no mention in the briefs and no mention in the arguments at all about the claim for unpaid salary and benefits that was dismissed by the court pursuant to a motion to strike. Mr. Padula got 2 bites at the apple in the lower court to plead the existence of facts demonstrating he was owed money. Didn't do it either time. We filed a motion to strike that was ultimately granted. There was no abuse of discretion in ultimately granting that and dismissing that aspect of the claims. To conclude, and to be very frank with this court, This case is about one thing only. It's an attempt by Mr. Padula to rewrite the documents which he signed. That's all it is. The trial judge, he saw right through it. Mr. Padula can say, trier of fact, or remand, or issue of fact, and let's get behind all this, all he wants. But the only facts that matter are attached to the complaint, and they were considered by the trial court. Those are the 3 documents that matter, and they clearly demonstrate that Mr. Padula had no right to purchase the company based on those indeterminate terms, based on the indeterminate term sheet. Definitive agreements had to be ultimately negotiated and executed. Never happened. The documents, including the employment agreement and the covenants, they clearly demonstrate at-will employment. Both parties could have walked away. They could have separated from each other. Ultimately, CCG made a decision, as was its right, under the employment documents, to walk away. That's what occurred. That's why the trial court dismissed the case. The law is absolutely clear, including cases decided by this District Court of Appeals. We respectfully ask that the decision of the trial court be affirmed. Thank you.
Counsel, you have just over 4 minutes.
I won't need it. I just want to bring up one point regarding what Mr. Zimmerman said, and I should say what he craftily said. He said, he was running through the employment agreement, running through the paragraph numbers. He goes, paragraph 5 involved the commission of certain enumerated offenses. Well, it turns out paragraph 5 actually reads early termination by the company for cause. And it's underlined as such. That's the one that defines cause. That's one that says it requires a 30-day notice of a violation if the company believes he's committed an action for cause other than a commission of a crime or filing of bankruptcy. This idea that we're trying to rewrite a contract, no, the contract's written. It says cause. It says cause all over it. It says 30-day notices, and it says that they can't terminate us for anything other than cause specifically. And so, again, this is a motion for judgment on the pleadings. All inferences in plaintiff's favor. There's been nothing presented to this court by the appellee that demonstrates plainly that no set of facts beyond doubt could be proven by the plaintiffs in this case that would entitle them to relief. So I'd say we're entitled to our day in court. Please allow us to go back to the court, build up our case through evidence, and submit it at that point. Please remand this matter to the trial court on all counts so they can be tried on the merits.
One of the documents says, in consideration of the things that Mr. Padula is going to do, he agrees to this. What was the consideration that Mr. Padula gave?
Okay. First of all, he left a former significant six-figure employment. I mean, when I say significant, he's making $300,000 or $400,000 a year.
In a similar business?
In a similar business. To come work with his brother-in-law to help start this business, make it viable, and then so he could be a business owner himself. That was the impetus for him to come there. Once he was there, he did exactly what he promised. He brought in, and again, a lot of this is pled, and all we got to do is look to the facts and the pleadings, because we assume them as true. He brought in more business than the company had ever done before in its history. And as it was about to close, he got terminated. As the business was about to actually pay the bill, he got terminated. And now all of a sudden, the employer's the brother-in-law is left holding a valuable business, far better than he could have done on his own, without paying his brother-in-law anything. Makes for some pretty rough Thanksgiving dinners, I imagine. So that's what the case will ultimately prove on the merits, but it was pled in the complaint. And again, we can only rely on facts pled in the complaint for the purposes of this consideration. So I think this is a very obvious matter. Every valiant arguments aside, the documents say what they say, and the pleadings say what they say as well. And the causes of action were properly pled. And so they should be remanded. Thank you.
Thank you all for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website. We are adjourned until next Tuesday. Thank you.